Okay, so thank you so much everyone for joining. My name is Jen Derby. I'm an attorney with Tucker Arensberg. Our topic for today is looking to the future and discussing digital assets and estates. So I was initially going to be joined by Olivia Brinker of Merrill. She unfortunately had a conflict this evening, and so it will just be me. So this may be a little bit shorter than we initially planned, but I intend to talk about the legal aspects of digital asset planning. And if you're just getting into the room right now, just so that you know, I am going to have everyone mute themselves and turn off their cameras. There is a chat feature on Zoom, so if you have a question, feel free to type in your question on the chat feature, and I will try to, I'm on this by myself, so I'll try to look at those every so often and make sure that I am addressing all of the questions. Let me just check our waiting room quickly to see if I need to admit anyone. No, we're good. We are good for now. Okay. So as I said before, my name is Jen Derby. I'm an attorney with Tucker Arensberg. I am specifically an attorney in our estates and trust group. So I help clients with estate planning, estate administration, elder law, and special needs planning. So as I mentioned, of course, we're going to be talking about digital assets today, but this just sort of falls, right under the umbrella of the types of cases that I typically handle. So let's dive right in. So I think, the first question that I get asked, or something, generally speaking, what we deal with as estate planning practitioners is the question, why are digital assets relevant? And why do I need to worry about this if I have my estate planning done already? And so, the background here is that 300 million there are 300 million internet users in North America alone. 90% of the North American population uses the internet. There's a growing number, of course, of websites and types of accounts, as we all know. And generally speaking, every person who is on this webinar and probably every person in that person's life has digital assets. So we'll get into shortly what are digital assets, but I think it's just so important to know, and especially even though this is a little bit dated, this McAfee study here states that the average perceived value of a digital estate is about $54,000. So, this is very, very significant. So the question here is, what is a digital asset? And so I think that's really important, because when I'm talking to clients, a lot of times they don't know the answer to that question. They generally understand that it's probably going to include a lot of what they have on their phone and their computer, but they're not sure what the digital asset is. So a digital asset defined under Pennsylvania law is an electronic record in which an individual has a right or interest. The term does not include an underlying asset or liability unless the asset or liability is itself an electronic record. So that is what we call legalese, and so there's a lot of specific terms in there, but really, what does that mean? I think it's helpful to break that down so you understand what that means. So a digital asset includes social networking accounts like Facebook, Instagram, Twitter, as well as email accounts, electronic mail accounts, electronic blogs, digital photos, loyalty programs. So all of those airline miles that we build up through Southwest Airlines and American Airlines, Delta Airlines, as well as virtual property. And then last but not least is Bitcoin. I know this is a big one. Bitcoin has become a lot more prevalent, I think, over the last few years, but that's also included. So why do we care about planning for digital assets? So one of the reasons is because we want to lessen the burden on our personal representative and our loved ones. So as I go through this presentation, you will realize that if planning for digital assets is not on your radar, not something that you're thinking about already, it needs to be, because this, if this is not planned for correctly, it can really create a bad situation or a tough situation for your loved ones upon your passing. So, and also, you know, there's sentimental value of digital property as well. So I don't know about all of you, but I know I have probably most of my life, including, you know, photos, videos, major moments in my life, major moments in my spouse's life, friends' lives, saved on my phone with a password connected to that phone. But, you know, I'm pretty much the only person that has access to that. So all of this stuff is really important to think about. So what has happened, you know, in the legal space over the last few years is that legislation has been created in, as you'll see in the next slide or the next two slides, legislation has been created in about almost all of the states. I believe it's 48 states at this point, to impose regulations regarding digital assets, just because the law essentially wasn't catching up to this issue of, you know, digital assets are not regular assets. Our homes, our tangible property, these are all regular assets, but digital assets are just totally different. So essentially, the law needed to catch up to that. So creating this legislation involves, you know, basically a balance between our right to privacy and also our right to, or the need to get this information. So that balance is really the reason why, you know, this legislation was important, but it's also very hard to figure out the right way to do this. So just to give you two examples of how this comes into play, this is actually a case from the United Kingdom, but there's, as you'll see on the next slide, there's a very similar case recently in New York. So basically what happened, and this is a case of an individual named Rachel Thompson against Apple. And so Rachel Thompson's partner passes away in 2015, leaving behind their son. Rachel wanted to recover photos and videos from her partner's iPhone for, you know, of course, for memory purposes. Apple's position here was that the user accounts are non-transferable and that the right to the content terminates on the account holder's death. They indicated in the opinion that the user can make provisions in their will specifying access to their account, but in this particular case, Apple required a court order to obtain access to these items on the decedent's iPhone. And so in this case in the United Kingdom, the judge made a comment that, of course, this was a 3-year legal battle as well, but the judge basically said there needs to be a simpler way to handle these types of cases. And the judge actually called this a digital duty of care needs to be owed to a grieving family member. So in a similar case, this one was called Sweezy out of New York State. Basically, an executor was trying to get information from their spouse's iPhone. The will did not specifically provide for disposition of digital assets. And ultimately in this case, the court ordered that Apple should turn the photos over to the surviving spouse. You know, and I think the most interesting thing about this case is that this person had left all of their assets in their will to their surviving spouse, but then their surviving spouse didn't automatically have access to what was stored on their iPhone. So what is really important as a takeaway from the Thompson case and from this case out of New York is that we need to take measures at the planning stage to ensure fiduciary access to digital assets. So as I'll discuss throughout, we need to make sure that our estate planning documents, our powers of attorney, our wills are including these provisions so that we're covered in case something happens. Okay. So I'm going to talk briefly here about the revised Uniform Fiduciary Access to Digital Assets Act, which is probably the longest name of an act that has ever existed. I'm going to refer to this as the Digital Assets Act and not read that whole thing every single time. So the goals, so basically we start here with this act that essentially has been enacted by, as I said, most of the states at this point. But the goals of this act were to grant fiduciaries legal authority to manage digital assets and electronic communications in the same way that they manage tangible assets and financial accounts. And also to grant the custodians of digital assets, meaning Google, Apple, Facebook, Instagram, legal authority to deal with the fiduciaries of their users, while also respecting the user's reasonable expectation of privacy for personal communications. So as I said before, this is a tough balance, but this is sort of the goal of this legislation coming into play. So under the Digital Assets Act, fiduciaries no longer have authority over the contents of electronic communications unless the user explicitly consented to the disclosure, and they can access other types of digital assets upon petition to the court with explanation as to why the asset is needed to administer the estate. And then on the custodian end, so again, that's from the view of Apple, Google, the holders of this information, they can request that court orders be required. They can limit their compliance by providing access only to assets that are reasonably necessary for wrapping up the estate. They can charge fees to comply with their request for access, and they can also make it difficult with paperwork if necessary. And they can refuse unduly burdensome requests. So as I said before, 48 states have enacted some law on digital assets, and 45 states have adopted the Digital Assets Act in some form. So even if the states aren't adopting the Digital Assets Act, they're putting something in place to make sure that this is handled correctly, or that this is covered, I should say. So that leads us to Pennsylvania's Act 72. So this is very important. I think most of us, attending this webinar are from Pennsylvania. So we do have our own form, or our own version of the Digital Assets Act. And so this was added to what we call the PEF code, the Pennsylvania Estates and Fiduciaries Code, as a new Chapter 39. So this has actually been included as law in Pennsylvania, and you can look it up online. It was signed by Governor Wolf on July 23rd, 2020, effective 180 days later, which made it officially effective January of this year. So what does it say? First of all, as I indicated before, with the purpose of the Digital Assets Act, the purpose of Act 72 in Pennsylvania gives individuals the power to plan for the management and disposition of their digital assets in the same way that they can make plans for their tangible property, which is by providing instructions in a will, a trust, or a power of attorney. So who is impacted, or what is impacted by Act 72 in Pennsylvania? So this act applies to fiduciaries, which would include fiduciaries under a will, which would include an executor, a power of attorney or an agent under a power of attorney document, a guardian under a guardianship, or a trustee under a trust. Act 72 does not apply to a digital asset of an employer that's used by an employee in the ordinary course of the employer's business. That's in section 3903. And I think I went over this slide at the beginning of the presentation to define what a digital asset is, but if you look at this list, I would think, generally speaking, most of us here can say, oh, well, I didn't know really, necessarily before this that I own digital assets, but I'm looking at this list and I have, the first bullet point here, I have Facebook. Most of us, if not all of us, use email. We have, a lot of us have a blog or some type of website, digital photos, again, loyalty programs, airline miles, points through a credit card, virtual property, and Bitcoin. I mean, these are becoming huge things. Something that I heard about recently from the perspective of virtual property are they're basically called digital, I don't know the exact word for them, but they're called digital playing cards. And it's like basically getting a pack of baseball cards or a pack of basketball cards. And so you own this particular basketball image, for example, but it's a live video. And so you can own someone's slam dunk, or you can own somebody hitting a home run in a World Series. And so, there are so many different things that are out there now that are digitally stored, but they're actually assets. And so we need to plan for how someone would get access to these, in an event of incapacity or upon death. So what about cryptocurrencies? This is getting into a brief discussion about Bitcoin. So cryptocurrency beneficiary designations or elections for those accounts will take precedence over account instructions listed in a will, trust, or power of attorney. But these cryptocurrencies are stored mostly on a blockchain technology that requires a private key to get access to it. So that helps, right? There's a private key. You can't just gain access to it, but a lost password or asset might be almost impossible to recover. So, these are really important as well. You can actually, in some instances, place your password in a digital vault with your financial advisor or an attorney or CPA, or save it on an encrypted flash drive. So I think one of the most important things included on this slide is the second part here. So it says, how do you locate digital assets? There's no shoebox of receipts, letters, or bills coming in the mail. And I think this is really important because, when I'm handling an estate for clients, often they do literally bring in a shoebox or a bin full of receipts and say, I don't know what my loved one had, but here's what I found, right? So we can have tangible things, we can have papers, we can find mail, we can find things that will help us lead to what this person's assets were. With these types of assets, there's no tangible thing to find. So a lot of this information can be confusing for loved ones to find. And so eventually, later on in the presentation, I'll talk about how to categorize these or catalog them so that they can be found. And so not only does planning for digital assets potentially complicate estate planning, but it also can complicate estate administration when someone passes away. So, digital assets, are they part of the estate? How are they identified? How are they accessed? How are our digital assets disposed of? So these are all really tough questions that, the purpose of Act 72 was to provide some guidance for some of these issues. And identifying digital assets is difficult as well. They're difficult to identify. There's no single gatekeeper. There's not a person you can go to that says, here's all of the accounts that existed for this particular person. And the planning here is, and you're probably thinking this maybe in the back of your mind, the planning for this is sort of counterintuitive, right? Because a lot of us do want to keep this information separate or private. We don't want to disclose this necessarily to everyone out there or to whoever we're choosing as our executor under our estate. So in a lot of instances, we're discouraged from recording passwords, and there's an infinite number of sites. So we can have, even one person can have, many different Facebook accounts, websites, different credit cards, bank accounts. And then, if we save passwords, we can have those passwords updated periodically. So passwords may not always be accurate as well. One of the important things to include here is that I mentioned throughout here end user agreements, or just generally agreements between a user and a custodian of these digital assets. So a lot of times when we're signing those agreements where it's, when you get a product, for example, you click at the bottom that says, yes, I agree to these terms. We're agreeing to a term of service or a user agreement with that particular holder of that asset. And so why that's important is we might actually, we should, number one, we should probably read those, but most of us don't. But sometimes we're agreeing to a particular way of, disposition of that digital asset by signing that agreement. And again, as I said, these will control if they survive the user's death. So I included at the end of this slide here, compare Gmail, which can pass to, to someone through your estate, to iTunes or Kindle, which cannot pass. And so I have some examples here on the next slide of, some of these programs that we all use and how those may be disposed of in an estate. So for example, Facebook is probably, of all the social media and all of the electronic outlets we have out there, Facebook is probably the one that has, the most thought into this digital asset issue. So Facebook allows for a legacy contact. So essentially what that means is you're allowed to designate someone who would be your contact upon your passing, and that person can direct what happens with your account. So you can actually, it's sort of like a beneficiary for your Facebook account. But in contrast, Instagram doesn't have that option. So, a lot of these sites, for example, you can essentially deactivate or even sometimes memorialize someone's account when they pass away, but they may not have the option for a legacy contact. Regarding airline miles, it depends on the airline. Some allow for airline miles to be transferred upon death with proper documentation or mention of the miles in that person's will. Others don't. Google, which we all use, or most of us use, I should say, very common to have Gmail or a Google account in some fashion. So Google has an inactive account manager function, which allows the user to name a friend or relative to be contacted upon death, but it does not give that person access to read their messages or emails, for example. And then with Apple, Apple only allows the transfer of an Apple account after a grant of probate and a court order. And so what I've been reading recently seems like that may be changing, but generally speaking, in talking about digital assets, it seems like Apple is one of the more difficult custodians of this information to get access to. So, of course, that begs the question: if all of us have, a lot of us, I should say, have some Apple product, whether it's an iPhone or an iPad, a Apple computer. So it's important to know that this stuff needs to be addressed in your estate planning documents at a minimum. So what is the hierarchy to accessing digital assets under Act 72 in Pennsylvania? I think this is very important. So first and foremost, the user's affirmative use of an online tool to grant or deny access controls over everything else. So if that particular site has an online tool that allows for access, then that will control. If not, then a user's grant of authority to a fiduciary in an instrument may enable access, which would include a power of attorney, a will, a trust. So if the access is not granted in the instrument, then the court may authorize access. So that's when a court may be necessary to get a court order to allow this information to be shared. And last but not least, fiduciaries may generally access a catalog unless the user or the court prohibit disclosure. And so I'll talk a little bit about the difference between a catalog versus actual content for digital assets. So a catalog is essentially sort of exactly what you would think it is, right? It is gives you or provides you with each person that has had an electronic communication with a user, the time and date of the electronic communication, and the electronic address of the person under paragraph 1, but it doesn't provide the content of the communications. It just says, it provides essentially that the communications exist, right? So the content, of course, is separate. So that is the actual substance or meaning of electronic communication. So in our power of attorney documents, we actually have a selection for clients to indicate whether they want their agent with regard to digital assets, whether they want them to be able to catalog those assets or have access to the content, or both. You can see obviously there's a difference, but this difference can be really important. So some of the key points for estate planning when we're talking about digital assets, and I think these are really important as well. So we want to talk about the nature and extent of digital assets in the estate. So consider the economic and or sentimental value of these assets, and also discuss the intent. So what does that person intend? Do they, it's important to have a conversation. Do they care if their heirs get access to this information or not? It depends on if someone has a career, for example, as a graphic designer or a photographer, then obviously they're going to want their family to have access to their work product. But if somebody doesn't want for example, their social media accounts to continue after they're gone, then they can designate that as well. So what is important about digital asset planning? What is the mental checklist, or the physical checklist, I should say, that you can take away from this presentation for things that you need to think about? And that would be including language, this number 3, including language in planning documents to grant fiduciaries access to digital assets. So that's including digital asset powers in your financial power of attorney, in your trust documents if that's necessary, and also in your will with regard to the authority of your executor. Number 4 here is a tough one, because I know some people are not comfortable with this, but it really is kind of the best way to keep track of digital assets. So entrusting passwords or granting immediate access to a reliable source, or obviously someone that you trust. So providing instructions to that person, and you may need to, think about a cryptocurrency vault, for example, if you invest in cryptocurrency or something similar to that. Last but not least, and again, this is not necessarily a popular one, but it's something to think about, is potentially minimizing the size of your digital estate. Is it possible to, if you're worried about someone getting access to these assets, is it possible to save them in another way to avoid the issue? So, just a lot of food for thought here. So as I was saying in the last slide, I think it's really helpful to provide everyone here with some tangible steps that you can take to make sure that you're planning for digital assets. So again, as I said, include the language in your estate planning documents, your powers of attorney, your trusts, your wills, and then again, entrusting your passwords, or leaving sort of a list to someone that you trust and that you can rely upon. Make a list of your online accounts, and those can include usernames and passwords, so long as they're secure and with a trusted person. Ensure your will provisions are consistent with your legacy contacts, for example. So, if you do have, if you want to make sure that your executor has access to your Facebook account, for example, then make sure that that person's also your legacy contact on that account, or any other type of account that has a similar designation as Facebook. And then review your terms of service. So with if you have significant airline miles or perk points from a credit card, make sure if you have the option to name a contact or not, because you don't want it to be use it or lose it when it comes to those, if you want to make sure that those get passed along. So last but not least here, I wanted to just mention something that's sort of a new and different thing under the law in Pennsylvania. This doesn't necessarily have to do with digital assets, but it really is sort of going in line with what we're able to do now digitally with estate planning. So both electronic and remote notarization are permitted in Pennsylvania now. Remote notarization came as, sort of a response to COVID to allow us a way to remotely notarize documents. It is now permanent under Pennsylvania law. So, that is a very important thing because, with the restrictions we had in place during the pandemic, it was not possible for a notary to be in front of someone. So the reason I put this slide here, I know this is not really pertinent to digital assets, but it really is showing you that our legislature in Pennsylvania and really across the country are making laws to sort of catch up with where we are in the world, right? I mean, right now, we are communicating and all of us are basically either on a phone or on a computer. And so we want to make sure that, all of the information that we exchange on the internet through a webinar or through our social media accounts or through photographs or anything, we want to make sure that that information, if it's important to us, of course, that it's planned for appropriately, and that if something happens to us, either as an event of incapacity or upon our death, that our loved ones would have access to it. Okay, so as I said, of course, this was supposed to be a two-part webinar, so I basically was only supposed to be speaking for half of it. So that's probably not a bad thing. It's 7 o'clock on a Thursday, so I'm sure most of you are ready to get along with your lives. But I really wanted to just sort of give a brief snippet on digital assets and sort of stress the importance of planning for them. But if anyone has any questions, my information is here. Here's my email address, my telephone number for, that's actually my direct number at work. If anyone needs to give me a call, if you have questions about this, I'm happy to answer any questions. And actually, I'll leave this information up here for a little bit. If anyone has questions, there is a chat feature on Zoom, so feel free to ask a question. You can also, unmute yourself and ask it that way. But if there are no questions, then thank you everybody so much for attending. If you have any further questions, feel free to reach out with an email. This is sort of an ongoing important topic, but there may be updates, there may be changes to this. So, to the extent that I can share them with you all, I'd be happy to do that. We're kind of trying to keep our eye on changes in the law in this area, but this is sort of a new and developing area for us as well. Okay, I don't see any questions here, so I am going to close the webinar. Thank you so much for attending and have a nice evening.